Hello and welcome. I am Dr. Manvendra Kumar Tiwari, and I am working as an associate professor at the Dharmshastra National Law University, Jabalpur. Today we are going to discuss preventive detention, continuing our discussion on fundamental rights forward. Today we will discuss the contours of Article 22 Constitution of India, which deals with preventive detention. We will try to understand preventive detention through passages so that subsequently we also answer some of the multiple choice questions in order to do practice in line with how the questions in the common law admission test are asked. Now, the passage reads, and this is on preventive detention. The literal meaning of the term denotes physical detention of a person which is of preventive nature. So this is about physical detention of a person, and the detention is in the nature of it being preventive. In law, it means depriving a person of his liberty by putting him in jail or confining him in a place with a view to prevent him from committing acts which may pose a threat to the defense and foreign affairs, security of India, or security of a state, or if it is likely to disrupt public order or disrupt maintenance of supplies and services essential to the community. So these are the grounds on the basis of which this preventive detention is exercised against a person who at large, whose liberty may actually be a threat to these concerns of the state. The deprivation of liberty in pursuance to an order of preventive detention is different from the deprivation of liberty in pursuance of an arrest. So this very categorically says that detention pursuant to an arrest is different from detention pursuant to an order of preventive detention. Arrest happens when a person commits the crime, or when a person is accused of having committed a crime, not commits the crime. That needs to be proven, and that is established only when a trial takes place. So arrest is when a person is arrested for having committed an offense, and there is suspicion that the person has committed. We'll continue this further. So the deprivation of liberty in pursuance to an arrest of preventive detention is different from the deprivation of liberty in pursuance of arrest. Arrest is when the person is accused of committing an offense. Here, the person is likely to commit an act which is prejudicial to what we just saw, the various concerns of the state. Arrest is made in the course of investigation after the commission of offense. Herein, the detention is punitive. By punitive, we must understand that though the conviction has not taken place after the conclusion of trial, but the person has been arrested because the person is suspected to have committed an offense. And in that sense, the detention following arrest is punitive. Whereas in case of preventive detention, as it is clear from the name itself, it is with a view to prevent a person from committing offenses of a particular nature, as mentioned above. Another name by which the term preventive detention is known is detention without trial. This means that the person, though detained and thereby deprived of his liberty, is not to face trial, as trial is conducted after the commission of an offense, so as to determine the culpability of the person accused. Clear that we already saw that trial would happen when there is an offense that has been committed and a person has been arrested. in case of preventive detention, since there is no offense that has been committed, so therefore there will not be any trial. It is worth noting here that the continuance of a person in jail after arrest facing trial or who is to face trial pursuant to the rejection of his bail petition is also a kind of preventive custody. But this is with a view to prevent him from prejudicing the fair conduct of the trial and therefore different from preventive detention. It is true that sometimes one of the reasons for the rejection of bail petition may also be to prevent the person arrested from committing more crimes because of the existence of such apprehension in the assessment by the court. Yet, his continuance in jail cannot, because of this reason only, be equated at par with preventive detention, as the attributes of preventive detention, as explained above, are missing here. So, this statement is actually telling us that sometimes a person who is arrested may also remain in jail because he is likely to commit crime if set at free. However, despite the fact that in such cases, the detention of the person, one of the reasons for the detention of the person is to prevent him from committing further crimes, the same cannot be equated with preventive detention. Because preventive detention is a different concept in law where a person is detained without being accused of committing a crime. And on the apprehension that he may likely do so, he may be likely to do so, and that is why the difference between preventive detention and continuance of a person arrested in jail so as to prevent him from committing further crimes, the distinction remains regardless of this similarity. In a constitutional scheme, so this is what the preventive detention is. Now we'll look at the constitutional scheme or constitutional provisions in our constitution related to preventive. In a constitutional scheme wedded to the concept of rule of law, it is very difficult to countenance a concept like preventive detention within its fold. Preventive detention is a necessary evil, but essentially an evil. This is so because individual liberty is one of the most cherished, jealously guarded by our constitution, by protecting it from the might of state. Right to life and personal liberty is assured to every person by our constitution under Article 21 of the Constitution, and its infraction is only permitted by way of a procedure established by law. So this passage is telling us how difficult it was to reconcile the idea of preventive detention with our constitutional scheme, which is wedded to the concept of rule of law. And it has only been accepted as a necessary evil because a person is not suspected to have committed a crime. So the person is not accused. And yet on the likely apprehension, person is put behind bars, is detained. And that's why this is something which is very difficult to be reconciled. The guarantee of personal liberty under Article 21, where the infraction of personal liberty under Article 21 is only permissible by way of a procedure established by law. In the Constituent Assembly, Dr. Ambedkar has regretfully made up his mind that the government would need the power, though it was subjected to severe criticism by some of the members of the assembly like Jaspat Roy Kapoor and Mahavir Tyagi. The constitution makers accepted preventive detention as a necessary evil. We tolerated in a constitutional scheme which otherwise guaranteed personal liberty in its well-accepted form. Having accepted it, they proceeded to create in terms clear and wide in their import certain procedural safeguards. These detailed procedural safeguards are given under Article 22 of the Constitution in Part 3 dealing with fundamental rights. So this passage is telling us that Dr. Ambedkar, who was the chairperson of the drafting committee of the Constitution of India in the Constituent Assembly, made up his mind to incorporate preventive detention only as a necessary evil, because he was of this view that government would need this power. And when he did so, he even faced criticism from some of the members of the Constituent Assembly. The Constitution makers therefore accepted preventive detention as a necessary evil. However, despite the fact that they accepted this in Article 22 of the Constitution, certain procedural safeguards were added in respect of preventive detention. Okay, so now we'll see some of the passages. We'll see some what are the safeguards in Article 22 after having answered some of these MCQs. So the first one here is the deprivation of liberty in pursuance to an order of preventive detention is different from the deprivation of liberty in pursuance of acquittal. No. Arrest, it to be true. Bail, no. Conviction, no. Arrest. Option B is the answer. Preventive detention is different from the deprivation of liberty in preventive detention is different from the deprivation of liberty in pursuance of arrest. So option B is the right answer. The purpose of preventive detention is punitive, no. Is reformative, no. To prevent a person from committing offenses of a particular nature appears to be correct. Option D, to prevent a person from committing robbery. Clearly, option C is the right answer. The person in preventive detention must face trial. No. Is not to face trial. Appears to be correct. Is to be convicted. No. Is to be acquitted. No. So, option B is not to face trial, because preventive detention has been undertaken without the commission of a crime and without there being a suspicion that the person detained is accused of committing a crime. So the person detained under preventive detention is not to face trial. In a constitutional scheme wedded to the concept of rule of law, it is very difficult to justify preventive detention. Appears to be correct. Not have preventive detention. Be true. Arrest a person. No. Convict a person. Clearly, option A is the right answer. It's very difficult to justify preventive detention in a constitutional scheme which has rule of law as a central doctrinal presence. Preventive detention is tolerated in the Indian constitutional scheme, which guarantees liberty, personal liberty, appears to be correct. Is established by law, due process of law. So clearly, option B is the right answer. Now we'll see passage 2, which is about Article 22 and the procedural safeguards provided therein. So Article 22 clearly says that arrest of a person may not need authorization from the magistrate. So Article 22, apart from preventive detention, also talks about arrest. So Article 22 says that arrest of a person may not need authorization from the magistrate. We know that under our Bharatiya Nagarik Suraksha Sanhita and under the erstwhile Code of Criminal Procedure, the offences have been categorized into two. One called cognizable and the other called non-cognizable. In cognizable offences, which are serious offences, the police has got the right to arrest the person accused without obtaining a warrant from the magistrate. So that understanding of CRPC and Bharatiya Nagarik Suraksha Sanhita is actually based on Article 22, which says it does not always need authorization. But as per Bharatiya Nagarik Suraksha Sanhita, if the offense is categorized as non-cognizable, then in that case, authorization from the magistrate in the form of a warrant would be required. The statement here is correct because it says it may not need authorization. So that distinction between cognizable and non-cognizable offenses to be kept in mind. Under clause 2, custody of the person arrested beyond 24 hours of a person detained after arrest must be authorized by a magistrate. So clause 2 provides for a safeguard in case of arrest. If the person arrested is to be detained for a period more beyond 24 hours, then in that case, authorization for that detention beyond 24 hours is required to be done by a magistrate. But clause 3b keeps preventive detention out of this requirement if the detention is under any law providing for preventive detention. So clause 3b does not have the requirement of clause 2 of article 22, which provides that if the detention has to exceed beyond 24 hours, then a magistrate's approval would be required. 3b of article 22 says that if the detention is preventive and it is under a law providing for preventive detention, then in that case, the authorization from the magistrate would not be required, even if the detention has to go beyond 24 hours. Now, in fact, subclause 4a lays down that for detaining a person beyond the period of 3 months under preventive detention, the extension must be authorized by an advisory board consisting of persons who are or have been or are qualified to be appointed as judges of a high court. So clause 4 is even contemplating a possibility where the extension may go beyond a period of 3 months. However, in that case, it provides for an advisory board whose consent must be obtained if the detention has to go beyond 3 months. Proviso to this subclause stipulates that the extension beyond 3 months authorized by the advisory board cannot exceed the maximum period prescribed by any law made by the parliament. There is a restriction that it cannot go to an unlimited extent. It can only be in line with a law made by the parliament, which will fix the maximum period of preventive detention. Under subclause B of clause 4, though, it is provided that the requirement of the authorization of an advisory board for extension of preventive detention beyond the period of 3 months can be dispensed with by a law made by the parliament to this effect, prescribing the circumstances under which and the class or classes of cases in which a person may be detained for a period longer than 3 months. So you have in clause 4b the requirement of an advisory board's approval for detention beyond 3 months. Even this can be dispensed with if it is so provided by a law. And the law must provide for the class or the classes of cases in which the person may be detained for a period longer than 3 months. This appears to give wide powers to the Parliament of India by dispensing the need for an independent scrutiny, which the intervention by the advisory board may have provided. Clause 5 puts a restriction on the authority exercising the power of preventive detention, providing that when any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such persons the grounds on which order has been made and shall afford him the earliest opportunity of making a representation against the order. It is important to note here that unlike the person detained by way of arrest, who under clause 1 of this article is given the right to consult and to be defended by a legal practitioner of his choice, clause B only provides for the allowing the earliest opportunity of making a representation against the order by the person detained himself and not by the legal practitioner. So there is, compared to the rights of an arrested person, the rights of a person detained under a law providing for preventive detention are lesser. Further, under clause 6, the requirement of disclosure of grounds for the order of preventive detention mandated by clause 5 can also be dispensed with if the authority considers such disclosure to be against public interest. So even the grounds for the exercise of preventive detention order may not be revealed to the person who is supposed to be detained preventively. If the person making the order of preventive detention is of the view that such disclosure would be against public interest. The contribution, this is again problematic, but as has been the case, it is a necessary evil, and that's why there are so many exceptions to the ordinary general rule. The contribution of Indian judiciary in upholding liberty of individuals sometimes gets shrouded in the skepticism because of one of the most widely debated and criticized verdicts of the Supreme Court in the case of Additional District Magistrate Jabalpur versus Shivakant. This was a judgment delivered during emergency days when the former Prime Minister of India, Indira Gandhi, had declared an emergency to the President of India. In this case, the petitions filed before the Supreme Court challenged the legality of the judgments delivered by 7 different high courts. The high courts had held that despite fundamental rights being suspended owing to the proclamation of emergency under Article 352, Clause 1 of the Constitution, and a presidential order to this effect under Article 359(1), courts in India cannot be stopped from enforcing the statutory rights of the individual. And in doing so, courts can even go into the question of malefides in relation to the exercise of executive powers, especially while exercising the power of preventive detention. Okay, so the argument of the High Court was, when the matters came before the High Court for decision, that even though there is a proclamation of emergency and all fundamental rights as per Article 359 would have been suspended, a person who has been preventively detained under a law still has got the right to question that decision in accordance with the law of preventive. So the government cannot come up with the argument that even this claim by the person who is detained preventively is not acceptable in the light of the fact that there is an emergency in operation and all fundamental rights have been suspended. Fundamental rights have been suspended, but that does not mean that application of the laws of preventive detention can be dispensed. And only if there is a judicial scrutiny by an independent judiciary that it can be confirmed whether laws of preventive detention are being adhered or not. But the argument here from the government of India was that even this scrutiny is impossible because all fundamental rights, including rights guaranteeing personal liberty, have been suspended. And therefore, no person can question an order which actually has the effect of depriving a person of his personal liberty. High courts disagreed. High court said application of law still needs to be there. And if there is a challenge that in respect of the non-application of the law, courts will have the right to examine the manner in which the executive order of preventive detention has been issued, whether it is in compliance with the laws which enable such passing of preventive detention orders or not. Against this, there was a petition filed before the Supreme Court of India, where the government argued that such a power cannot be exercised by the judiciary, by the courts, because there is an emergency proclamation existing and all fundamental rights have been suspended. Therefore, nobody can question an executive order on the ground that whether the executive order is complying with the law or not. The Supreme Court, by a 4:1 majority, overturned the decision of the 7 high courts and declared that owing to continuance of emergency and the presidential order suspending the fundamental rights conferred by Article 14, 21, and 22, the High Court cannot examine whether an order of detention is in accordance with the provisions of Maintenance of Internal Security Act or not. This was the law under which the preventive detention orders were being issued. And that's why the Supreme Court said that the courts cannot examine whether the preventive detention orders are actually being issued complying with the provisions of the Maintenance of Internal Security Act or not, which constitute the condition precedent to the exercise of such powers thereunder, or whether the order was malified or was made on the basis of irrelevant materials by which the detaining authority could have been satisfied that the order was necessary. The majority judgment was delivered in 4 separate concurring opinions by Justice A.N. Ray, who was the Chief Justice, M.H. Beg, Y.V. Chandrachud, and P.N. Bhagwati. The sole dissenting opinion was delivered by H.R. Khanna. The majority verdict is cited by many even today as an example of utter surrender of the Supreme Court before an absolutist government. Pursuant to this verdict, the Constitution 44th Amendment Act in the year 1978 has now amended Article 359 Clause 1 and made fundamental rights flowing from Article 20 and 21 non-derogable even during emergency. That's an important development. Now we'll see a few questions based on this passage. Under Clause 2 of Article 22, custody of the arrested person beyond 24 hours must be authorized by the magistrate. Know that arrest may not be authorized, but the custody beyond 24 hours of an arrested person has to be authorized by the magistrate. So option A is the right answer. Preventive detention under a law providing for preventive detention needs authorization from the magistrate. No authorization from the magistrate. Strict authorization from the magistrate. None of the above. So clearly option B is the right answer. Preventive detention beyond 24 hours under a law providing for preventive detention needs no authorization. Preventive detention, in case as is the case, preventive detention under a law providing for preventive detention needs no authorization. And preventive detention even beyond 24 hours needs no authorization. So clearly option B is the right answer. Only if it exceeds beyond 3 months that an advisory board's approval would be needed. Clause 4 of question number 4. Under Clause 6 of Article 22, the requirement of disclosure of grounds for the order of preventive detention mandated by Clause 5 can also be dispensed with if the authority considers such disclosure to be against public interest. That's directly borrowed from the passage. State interest, private interest, interest of person retained. No, these are not the right answers. Option B, public interest, is the right answer. Finally, the last question. The Constitution 44th Amendment Act 1978 has now amended Article 359 Clause 1 and made fundamental rights flowing from Article 20 and 21 derogable. No. Article 20 and 21 non-derogable even during emergency appears to be correct. Article 20 non-derogable, 21 is missing. Article 21 not, so 20 is missing here in option D. Clearly option B, both Article 20 and 21 have now become non-derogable rights because after this amendment, the government can declare suspension of fundamental rights, but the government cannot declare the suspension of Article 20 and 21 as fundamental. So these two fundamental rights are therefore non-derogable fundamental rights. So with this, we come to an end for today's session. Thank you very much. See you soon in our next video.